Hi everyone. Now let's discuss topic 4 of Unit 5. Intellectual Property Rights, IPR in Cyberspace. Intellectual Property Rights, IPR, are the legal rights given to creators and owners of inventions, designs, artistic works, software, and digital content. In cyberspace, IPR ensures that innovations and creative works are protected from unauthorized use, duplication, or piracy. In simple words, IPR is like ownership rights for ideas and creations. Just like land or a house belongs to someone, a software, logo, or ebook also has an owner who must be protected legally. 2 mark questions. Define intellectual property rights, IPR. Name 2 types of IPR relevant in cyberspace. What is copyright and what does it protect? Mention 1 type of IPR infringement online. Give 1 example of IPR protection in digital content. 5 10-mark questions. Explain the importance of IPR in cyberspace. Describe different types of intellectual property rights with examples. Discuss common IPR violations in the digital environment. Explain best practices to protect digital assets and software. Illustrate with an example how a company can enforce IPR in cyberspace. Introduction to Intellectual Property Rights, IPR. Intellectual property rights, IPR, are legal protections granted to creators and owners of original works, allowing them to control, use, and profit from their creations. In the context of cyberspace, IPR safeguards digital content, software, multimedia databases, and online inventions from unauthorized use, duplication, or distribution. These rights ensure that creators retain ownership and control over their work in the digital environment, giving them the ability to protect their innovations legally. Cyber laws, along with copyright, trademark, and patent regulations, play a key role in protecting digital innovations. For example, software companies secure their code under copyright and patents to prevent competitors from copying or distributing it illegally, thereby maintaining their competitive advantage and intellectual property ownership. Types of intellectual property in cyberspace. There are several types of intellectual property rights, IPR, that protect creations in the digital environment. Copyrights protect original literary, artistic, and software works, including software code, ebooks, online articles, digital art, and music. In India, copyright protection typically lasts for the creator's lifetime plus 60 years. Patents safeguard inventions and technological innovations, including software-related innovations such as algorithms, processes, or system designs, provided they meet the criteria of originality and novelty. Trademarks protect logos, brand names, and symbols used online, preventing others from misusing or imitating a brand's identity in e-commerce platforms, websites, and applications. Finally, trade secrets protect confidential business information, such as source code, proprietary algorithms, or business strategies. Companies maintain trade secrets through non-disclosure agreements, NDAs, and strict internal controls to prevent unauthorized access or leaks. Importance of IPR in cyberspace. Intellectual property rights, IPR, play a crucial role in encouraging innovation and creativity in digital technology. They help prevent unauthorized copying, piracy, and plagiarism, ensuring that creators retain control over their original work. IPR also provides legal recourse in case of infringement, allowing creators to take action against those who violate their rights. Moreover, it supports the monetization of digital content and software, enabling creators and organizations to earn from their innovations. Protecting intellectual property also enhances the trust and reputation of creators and businesses in the digital environment. For example, YouTube creators use copyright protection to prevent others from downloading or monetizing their videos without permission, ensuring that they benefit from their original content. IPR infringement in cyberspace. Intellectual property rights, IPR. Infringement occurs when someone uses digital creations without the owner's permission. Common online violations include software piracy, which is the illegal copying or distribution of licensed software, and copyright infringement, such as using music, images, videos, or articles without authorization. Trademark violations happen when websites or apps imitate famous brand names to mislead users, while patent infringement involves using patented software algorithms without permission. Plagiarism in digital content, such as copying blog posts, articles, or academic work, is another common violation. Penalties for IPR infringement include civil remedies, like compensation, injunctions, or seizure of infringing material, and criminal remedies, such as fines or imprisonment, depending on the severity of the offense. These measures ensure that creators' rights are protected in the digital environment and deter unlawful use of intellectual property. Best practices for protecting IPR in cyberspace. To safeguard intellectual property in the digital environment, creators and organizations should follow several best practices. First, it is important to register copyrights, trademarks, and patents legally and on time to establish formal protection. Digital rights management, DRM, can be used to secure software, multimedia, and other digital content, while watermarking or encryption helps prevent unauthorized copying or distribution. Companies and creators should also sign non-disclosure agreements, NDAs, and licensing agreements with employees or collaborators to protect confidential information. Regularly monitoring the internet for unauthorized use or piracy of digital assets is also essential to detect and act against infringement. Real-world examples demonstrate the effectiveness of these practices. Software companies like Microsoft and Adobe enforce copyright on their software to prevent piracy. E-commerce platforms such as Amazon protect their logos and brand names through trademarks. Digital content creators like Spotify, YouTube, and Netflix use copyright and DRM to safeguard music and videos, while startups often protect innovative algorithms through patents and trade secrets. Following these best practices ensures that intellectual property remains secure, legally protected, and monetizable in cyberspace. Thank you. Please like, share, and subscribe.